Facebook, hey, lots of people use it, but are those postings admissible in a court of law? Well, it takes us to this week's case. It involves a real man, Joseph Gumpher III. Joseph was a fellow working in Pennsylvania. He had a family, held a job, and he quit his job, and then he applied for unemployment compensation. When he applied for unemployment compensation, he also made some postings to Facebook, and on the postings he made such comments as, I chose not to work, and I want to take some time off and relax for a while. Well, when he applied for the workers' compensation, the referee who heard the claim looked at the Facebook postings and said, well, Joseph, I find that you are not entitled to unemployment compensation. And Joseph appealed. He appealed to the Workers' Compensation Commission. And there, the review board said, guess what, Joseph? We agree with the referee, and we find that you are not entitled to unemployment compensation. All right. So Joseph decides to appeal this to a court, and it follows the normal way in which these cases are handled in Pennsylvania. So now going into a court of law, and by this time he has himself an attorney. Now the attorney is arguing, hang on here, here's what really happened, he argues on behalf of Joseph, is that he had to leave his job because he and his wife were both employed in the evening hours on a nighttime shift, and they had minor children who were being unattended at home, so one of them had to quit their job, and Joseph quit his job to take care of his kids. Therefore, he had a necessity which compelled him to quit his job, and under Pennsylvania law, they argued that if someone has a necessity, the need to take care of children, that will be sufficient for them to have to quit their job, then they are entitled to unemployment compensation. Okay, now on the other side of that it was argued, wait a second, there was never any argument made when the application was first made and when it went up on review, there was never any argument made that Joseph needed to quit to take care of his children. Never any argument of that. More importantly, with regard to the Facebook postings, he never objected to those Facebook postings becoming part of the record. And so now here we are at this point in the hearing, and we're here in a court of law, and we don't have any evidence that he needed to leave his job in order to take care of the kids. More importantly, we didn't have any objection when the Facebook postings came into the record. And more important than that, we find that here in Pennsylvania, there is case law that finds that Facebook postings can come before the court. So, bottom line on all of this, we find that is to the most important argument, the need to quit his job to take care of kids. No evidence of that was submitted at the initial application and on the initial review. So there's no evidence of that before the court. And also, we find that the Facebook postings can come in under Pennsylvania law. While in this instance, they're not determinative, they certainly do give an indication as to what he was doing and what was going on, and the person who's making the decision on this, the judge or a jury, can take a look at that and see to what effect it has on the case. Okay. So what do we learn from this case? What do we learn from this case? What we learn from this case is a very simple thing. And that is, if you're going to post to Facebook, know what you're posting. And most importantly, recognize that when you Facebook post, you are putting things up on a bulletin board that is open to the World Wide Web. That means everybody in the world can see it. And if you can get involved in litigation, the people on the other side of that litigation can take a look at those postings that you made, whether it's to Facebook or elsewhere, because that is a posting you are making on the World Wide Web. Okay, we bring you this cases, we bring cases every week, so you understand how the law works. I'm David Allen.